Okay, class, this should be lecture 4. Looks like pretty much everyone's doing good in the class. I did notice that it looked like some folks didn't watch the lecture 3. Um, as far as quiz number 2 went, it looks like everyone did pretty good. About close to half the class got perfect grades, but there were several students who missed quite a few. And my guess is that perhaps you're not watching the lectures. I know they're boring. I try to get them done quick, but you guys really got to watch those things because that's where all the information's at. So anyhow, we are this lecture. It's lecture 4. It's going to be for quiz number 3. You guys will have already taken test 1 by now. You also will have a project due, and the project is specifically on protective orders. You guys should have. You're going to have your protective orders project that you need to complete, and then you're also going to have your quiz number 3 that'll be due. So, what we're going to start off with, if you print out your protective orders project, we're just going to go down the line. And what I want you guys to do is listen to what I say, but also add your own information. I've given you part of the actual learning domain from the academy, and I told you where to go for that in the chapter, specifically chapter 4, that's going to have some really good info on what we're going to cover. So anyhow, we're going to start off with contempt of court on the project sheet. Contempt of court is covered under 166A4 of the Penal Code, and it's just a misdemeanor crime. Think of contempt of court if you do something that upsets a judge. Not necessarily domestic violence. That's going to be a little bit different. But say you call the judge a big butthead in front of him or her, that's not going to go well. You're going to be held in contempt. Or if you violate a simple order of the court, that could also be considered contempt of court. So we're talking a misdemeanor crime. Typically, it does not involve domestic or family violence. Okay, and basically, you've done something against the court's orders. Okay. The next one is pretty important. It's called Emergency Protective Order, or an EPO. Now, an emergency protective order is something that all police officers can get. It's basically an immediate, short-term protective order. It's requested by the responding officer. So the officer that shows up on a scene, if he or she feels that the situation is serious enough through domestic violence or family violence, then he or she can request through a judge right there on scene, literally get on the phone and call the judge, can request an emergency protective order. Again, it gives immediate short-term protection to the victim and the victim's family. It's always requested by the responding officer, and it's good for about 5 to 7 days, or long enough for the victim to get down to family court and get a more permanent restraining order that we'll talk about. Okay, so EPOs are very important. The next restraining order we're going to talk about is an ex parte restraining order. Ex parte restraining orders are a type of restraining order. There's one that's going to be very specific to domestic violence, but an ex parte restraining order in general is a restraining order issued without prior notice or hearing. Okay, so this is a restraining order that the judge hasn't even reviewed yet. However, the court, or the clerk in this case, the court clerk will have perhaps stamped this and made it valid. Now, this thing is going to remain valid until your day in court, which is typically about anywhere from 14 to 21 days away from the day the ex parte restraining order is issued. And then you're going to be given an order to show cause date. The order to show cause date is the date that you will actually stand before the judge, you and the other party, and you're going to argue your case. And then the judge will determine whether or not to basically continue on with the restraining order, or to quash it, basically make it go away. So remember, an ex parte restraining order is just done away from the judge. The judge doesn't have anything to do with it. There's no review until 14 to 21 days later, when an order to show cause date occurs. The reason they do this is to give that immediate protection to the protected person. That this protected person doesn't wait until the court doesn't have to wait until the court becomes available. Okay, so that's ex parte restraining order. Now the next one is a domestic violence temporary restraining order, also known as a DVTRO. Now this is the most commonly acquired ex parte restraining order. Okay, remember that. It's specific to domestic and family violence, a DVTRO. So it is an ex parte restraining order. It's the most commonly acquired one for domestic violence and family violence. So this is going to be the restraining order. Say, for instance, let's go back. Say an officer shows up on scene of a domestic violence, determines that the victim needs an EPO, or an emergency protective order. So, excuse me, with an emergency protective order, the responding officer requested on scene. So the responding officer would call the judge. The judge would most likely grant the restraining order if sufficient facts were there. That EPO, or emergency protective order, will be good for 5 to 7 days. And then we say, or until the victim gets a chance to go down to family court and get a more permanent restraining order. The more permanent restraining order is going to be the domestic violence temporary restraining order. That's the one you'll get in court. Now that's the one, remember, it is an ex parte restraining order. So the victim or protected person is going to walk into court. You're going to fill out the domestic violence temporary restraining order paperwork. You're going to submit it to the clerk. The clerk will then stamp it once they decide that everything's completed. That restraining order is now valid. And you have typically 14 to 21 days before you're given a court hearing known as a order to show cause. On that order to show cause, that's the date you and the restrained person stand in front of the judge, and the judge decides whether or not to continue the restraining order or to quash it or make it go away. Okay? The next one is what we call an order after hearing. Okay, an order after hearing, sometimes you'll hear this called a permanent restraining order. It could be, but really what we're talking about here is the next step. So the EPO, the emergency protective order, it's requested by the responding officer on scene of a domestic violence or family violence. The responding officer will request the protective order from the judge. If the judge grants it, then the restraining order is good for about 5 to 7 days. It's going to give the victim more time to go down to family court and get a domestic violence temporary restraining order, which is the most commonly acquired restraining order, has to do with family and domestic violence. That is typically good for 14 to 21 days or until the order to show cause date. Now, on that order to show cause date, if the judge grants or upholds the restraining order, allows the restraining order to continue, that is now going to be called an order after hearing. An order after hearing is a order the judge will place, and it's good for about 3 to 5 years. So we call it like a permanent restraining order, but it isn't necessarily, because it's only good for 3 to 5 years, but it's certainly considered permanent in the context of what we're dealing with here. Now, if after 3 to 5 years you're still having problems, it probably would not be that difficult to go back to court and get that restraining order extended. Okay, so that's an order after hearing. You don't often hear them called that. Most of the time we hear them called, well, I got a permanent restraining order, or, you know, that you'll never, hardly ever hear it called an order after hearing, except in this class. Okay, the next one is one that happens specifically in court, criminal court. So say I arrest someone for 243.1 or 273.5, which point 5, which you guys know about now, and then we go to court. Well, maybe I requested an emergency protective order, but the victim is being kind of wishy-washy on how whether he or she wants to proceed with charges. The prosecutor, in this case, the deputy district attorney, can actually request a criminal stay-away order. That's the next one for criminal stay-away order. The prosecutor can request a restraining order right in court. Okay, and this restraining order is going to be valid basically until the case is concluded. And by concluded, there's only more or less just two ways it could go. The bad guy is acquitted, that means found not guilty, or convicted, or found guilty. So either way, that criminal stay-away order may only stay in effect while the case is ongoing. When the person is acquitted, of course, the judge may end up quashing the warrant or making it go away. If the person is convicted, it may be a moot issue because now if the person goes to jail or prison, they're going to be held there. If they're released on probation, their probation status will often indicate some sort of restraint. Or the court can on its own decide, hey, we're going to issue an order after hearing. Okay, so that's a criminal stay-away order. Again, it's requested by the prosecutor in a case. Okay. The next thing I want to talk about briefly is something called foreign orders. Now, foreign orders aren't what they sound like. They aren't coming from like Schwangau, Austria, or anything like that. These are orders issued within the United States, any of its territories, any of its insular possessions, any military, U.S. military land. So basically what we're talking about is the United States. So we have an agreement with all places that are the United States that a restraining order issued in Riverside County, if it's a domestic violence or family violence restraining order, will be good anywhere in the country. Any of its insular possessions, any of its territories, any military, U.S. military land. So if I have a restraining order, a domestic violence restraining order, it would be called an order after hearing, good for 3 to 5 years, remember. If I have one of those issued against me, and I follow my wife to Greensboro, North Carolina, even though I'm from Riverside, and I commit some sort of offense that I cannot as a restrained person in the restraining order, then I could in fact be arrested for violating that restraining order, even though the jurisdiction is not the same, even though we have a Riverside jurisdiction and now the crime's occurring in Greensboro. So any restraining order for family violence or domestic violence issued within the United States, insular possessions, territories, which would be like Puerto Rico, Guam, American Samoa, any military base, so even NATO base in Italy or any of the other military bases, that restraining order will now be good any place else within the United States. If I get a restraining order, say in Canada, a domestic violence restraining order, that restraining order is only going to be good in Canada. I cannot, in fact, violate it here in the United States, but it would certainly lead to issue if I were committing similar domestic violence here in the United States. We would just start our own new case. Okay? So that kind of covers it as far as the definitions of the restraining orders. There are a few things I did want to cover too as it relates to restraining orders, okay? And please, guys, make sure you're looking in your book, the textbook, and you're also checking out Chapter 4 of that learning domain, number 25, that I sent you the link for, okay? Okay. So now I have a domestic violence restraining order issued against me. Let's just call it, for sake of argument, let's call it in this case a domestic violence temporary restraining order. Okay, the victim or the restrained person has requested this in civil court or family court, and it's going to be good for 14 to 21 days or until my order to show cause date. Okay, so it's valid. I've been served. So the restraining order is in full force and effect. Now, for some reason, I decide to go talk to the protected person of this warrant, okay, or the restraining order, I'm sorry. So I go over to her house and I'm like, hey, let's hang out. And I go, are you okay with that? And she goes, yeah, sure, absolutely, it's okay, come on in. And you're like, I'm good because I have a restraining order, you know that. Yeah, I do, but I'm saying it's okay. I'm going to tell you it's not okay, okay? If for some reason the police are called to that location, we will arrest the restrained person. Why? Doesn't matter what the victim says. What matters is that a judge has ordered this person. There's an absolute order that they shall not be anywhere near this victim. And if they violate that, then they're going to be arrested, okay, for a restraining order violation. The victim is not ordered by the court, only the suspect. Okay, so inviting over is not a defense. Want to make sure you guys understand that. Okay, let's talk a little bit about the kind of systems. There's we all have computer systems for everything now, and they're networks, law enforcement networks. For years and years, all domestic violence restraining orders were, oddly enough, in a system we called Dvtro, a domestic violence restraining order system. This was unique to California, but it also tied in with a national law enforcement telecommunications center. So if you had a restraining order in California and someone ran this person in Arizona, most likely the California restraining order would show up. Okay. But in terms of California, since we're focusing a lot of our class on the state of California and its laws, we no longer use the system Dvtros, Dvtros, a domestic violence restraining order system. Instead, we use a system called CARPOS. And CARPOS is basically the California Restraining Order Restraining and Protective Order System. So CARPOS, California Restraining Protective Order System. Okay, so just remember that typically we run our folks through what they call CARPOS. Okay, it's an acronym, but it's an updated version of Dvtros, Dvtros. Okay, make sure you understand that. Let's see. I'm just trying to make sure we cover everything here. Okay. Sorry, guys, I'm just making sure we cover all our topics here because I don't want you guys to be in the dark on anything. So all of these restraining orders that we discussed in the beginning of the video, generally the victim has to be cooperative. The victim has to be cooperative on any sort of ex parte restraining order or domestic violence temporary restraining order because the victim or the protected person is going to have to go to court and fill out the paperwork. Okay? An order after hearing, generally the victim will have had to have cooperated in court in some way. But there's one restraining order that we could get without the victim's permission called an emergency protective order, the EPO. Remember, that's the one that any peace officer can request at the location of a family violence or domestic violence. So if we say we show up to a domestic violence call, say a 273.5, a felony domestic violence, and the victim says, no, I don't want him arrested. I love him still. Please, officer. It was just an argument. If that officer truly believes that violence will continue and that this victim is at risk and maybe at this point in time not making good judgment calls, the police officer can request the EPO, the emergency protective order, without the victim's consent, without the victim's permission. If the judge grants it, the restrained person or the bad guy is going to have a restraining order against him. Okay, so I don't want you guys to think that the victim always has the ultimate decision. If we as police officers believe that the victim is not thinking clearly, perhaps caught up in a victim cycle of violence, then we could step in and we could basically order that suspect away from the victim. Okay, we could keep them away from the victim. It's granted by a judge, so it's not us making the decision. But an EPO, or an emergency protective order, is the one time we could request this restraining order despite the victim's objections. Okay? What happens, and this happens quite a bit, what happens if a victim and a suspect get into the game of dueling restraining orders? This happens quite a bit, believe it or not. So maybe, let's say the victim's gone out. Maybe the victim gets a criminal stay away order. Let's use that as an example. So the victim has been abused. Let's say a 273.5 felony domestic violence. Okay, and they are in court, and the prosecutor request a criminal stay away order. Remember, that's the one where the prosecutor requests it from the judge. The judge grants it. In a criminal stay away order, the restraining order will last as long as that case lasts, okay? Until the suspect is either acquitted or convicted, okay? So that restraining order is in effect. Well, what the suspect does is he thinks he's smart, so he or she will go down to family court and get an ex parte restraining order. In this case, a domestic violence temporary restraining order. Why would he or she try to get that? Because a judge won't look at it right away. How long will it go until a judge looks at the case, or until the order to show cause date? We said 14 to 21 days. So in this case, the suspect gets a real restraining order that's good for 14 to 21 days. Well, the thing about an ex parte restraining order, or a domestic violence restraining order, it is considered a civil restraining order because it's requested in civil court. A restraining order issued in criminal court, oddly enough, is a criminal restraining order, the criminal stay away order. What happens if you show up on scene and you have one person has a criminal stay away order and one person has a civil restraining order, or a domestic violence temporary restraining order? We're always going to go toward the criminal restraining order. That tends to take precedence in almost all cases, okay? So make sure you understand that. And let's see. One more point I want to make, and it's kind of a sensitive one with law enforcement, but it's important. Who commits domestic violence? Everyone. Okay, we've already said poor people, rich people, all the things that go along with domestic violence, drinking and using drugs. That's all across the socioeconomic lines. Okay, a rich person will just drink, more expensive alcohol and use more expensive drugs. But what about cops? Yeah, I've arrested a lot of cops for domestic violence. It's not fun, but it is something that does happen because police are just people, and we tend to commit crimes too. Okay, hopefully not as in the same amount as the rest of the folks, because we should absolutely be held to a higher standard. But what happens if a police officer does commit domestic violence? Or let's just say in this case, a police officer gets a domestic violence or family violence restraining order issued against him or her. Well, the law says we can't carry a gun. That's one of the things about a domestic violence or family violence restraining order. You cannot possess a firearm. Well, cops use guns for their job. So what we're saying is that if a cop is issued a restraining order, domestic violence or family violence restraining order, that cop can no longer possess or control a firearm. So what happens? If we find out that a police officer is involved in domestic violence, okay, and we don't even need to have the restraining order component, But if we show up to a domestic violence or family violence incident with a police officer, a couple things are going to happen. Okay, we are most likely going to have to notify our own supervision. That would be pertinent. And then our supervisor will typically contact the officer, the suspect officer's supervisor. If that officer works for our own department, then it's easy. But if they work for an outside department, we're going to have to contact that officer's supervisor, the suspect officer's supervisor, and that immediately that officer will have to relinquish their firearm. Okay, so basically, if a suspect officer is accused of domestic violence or family violence, the very first thing that should happen is that officer, the suspect officer, should directly notify his or her supervisor and should immediately relinquish their firearm to their supervisor. If you're the arresting officer or responding officer to the scene, then you should as well contact your own supervision, let them know, hey, we have a cop suspect here, and your department will then contact the offending officer's agency, and that process will go through. Okay. Officers aren't fired right away for this. There is still due process. They will certainly, most likely, like I said, have their firearm taken away immediately as a precaution. But we still have the right to go through some level of due process. Remember, if it's a restraining order that was just issued, we have an order to show cause date and other things like that. Okay? So, don't want to load your brains up too much, but guys, please do the reading. Okay, that's very important. Make sure you go over Chapter 4 in the learning domain that I gave you the website for, and listen to the videos. I know they're a little bit long. I try to keep them within 25 minutes or so. But I'm giving you guys a lot of information in these darn lectures, so you need to make sure you're keeping up with that, okay? And I think that's it for now. If you guys have any questions for me, make sure you email me, and we'll get those answered. But we're moving right along pretty good, and thank you guys.